behalf of the Indian Law Institute, Kerala State Unit, I'd like to wish everyone who has joined us today a very good evening. My name is Mita, and I will be hosting this session, a series of online lectures organized by the Indian Law Institute, Kerala. Today's lecture is by Advocate Mini Thomas on the fall of Roe versus Wade and reproductive healthcare access in India. Now, I request Advocate Lakshmi Sridhar to welcome the gathering and introduce.
Hello, good evening, everyone. My name is Lakshmi Sridhar. Today, on behalf of the Indian Law Institute, Kerala Unit, I would like to welcome each and every one of you to this lecture, which is part of the online lecture series conducted by the Indian Law Institute. First and foremost, I would like to welcome the President of ILI, Honorable Mr. Chief Justice S. Manikumar, the Executive Chairman of ILI, Honorable Mr. Justice Alexander Thomas. I would also like to extend a warm welcome to the Honorable Judges of the Kerala High Court, members of the Executive Committee of ILI, and the Kerala High Court Bar Association, and everyone who is virtually present in this meeting. Today's lecture is by our guest, Advocate Nini Susan Thomas, who is an alumni of the National Law University, Jodhpur. She's a Fulbright scholar who graduated as a public interest honorary from Columbia University, New York. Advocate Nini was awarded the LLM Public Interest Fellowship from Columbia to work with the International Legal Foundation, working on issues of criminal defense and legal aid of vulnerable population, and with women and children in conflict-affected countries like Myanmar and Afghanistan. While at Columbia, she also worked with multiple organizations on gender and sexuality issues. She was a litigation associate for Senior Advocate Sanjay Parekh in Delhi, where she worked mainly on social justice issues, including gender and reproductive rights. She has also worked as litigation associate at Project 39A, National Law University, Delhi, representing prisoners on death row. She has also worked as a legislative assistant for Binay Visham, Member of Parliament. A warm welcome to Advocate Nini Susan Thomas. I'm sure she will be able to take us through the different aspects of today's topic, fall of Roe versus Wade, and the reproductive healthcare access in India. I cannot emphasize enough on the importance of today's topic because the US Supreme Court on the 24th of June overturned the landmark judgment of Roe versus Wade, which made abortion a constitutional right as part of the right to privacy in the United States of America. The court has now conferred the right to individual states to ban and restrict the procedure themselves. It is so sad that when countries that otherwise pride on equality and personal liberty pass laws that take away women's bodily autonomy and her right to choice, and it makes it clear that what guides the governance is still the patriarchal and moral conscience, despite scientific advancement and rational thought. This decision is problematic in a sense that it only bans safe abortions, paving way for illegal abortion procedures. I hope Advocate Nini will be able to guide us through the implications of the decision and the related concerns. Once again, I welcome you all. Thank you.
Thank you, Advocate Lakshmi Sridhar. Today's session is being live streamed on the YouTube channel of the Indian Law Institute, Kerala State Unit, and will also be available for subsequent viewing. I'd like to mention that there will be a short question and answer session at the end of the lecture. The audience may send in their questions using the comment section on the YouTube channel. Without further ado, I pass the screen to our esteemed speaker to discuss the fall of Roe versus Wade and the contemporary issues of reproductive healthcare.
Thank you, everyone. Justice Manikumar, Justice Alexander Thomas, other judges of the Kerala High Court, and other advocates who are listening in and friends who are listening in, good evening. I would like to extend my gratitude to the Kerala unit of the Indian Law Institute for inviting me to this discussion. And as Advocate Lakshmi Sridhar mentioned, the fall of Roe v. Wade and another judgment called Pennsylvania versus Casey, which really gave a constitutional protection to the right of abortion in the United States, has surely had drastic consequences almost immediately after, with states putting in partial and complete bans on restriction or reason-based restrictions on abortion immediately after the judgment was passed in June of this year. If anyone is interested, there's a very interesting toolkit that has been made by the Center for Reproductive Rights that can be viewed on their website, which live tracks all of these restrictions which have come in place since Roe and Casey were overruled. And we've also seen cases where women who genuinely require abortion cares due to ectopic pregnancies and miscarriages who have not been granted. We've also seen extreme cases where there was a case of a 10-year-old minor victim who, when asked for termination, was told to view the abortion as an opportunity. And we can really see how these have resulted in life-threatening situations. And when we really wonder whether a judgment in the US will have ripple effects in other countries, actually, just like last week, when there was a case of termination of an abortion before the Delhi High Court, it was very interesting to note that comments that were made in the US Supreme Court during the hearing in this case, such as that why should women abort? Why can't they just have the child and give the child up for adoption? These comments were also reflected, if the reportings on the hearing are to be believed, were also made by judges of the Delhi High Court. Very interestingly, after Justice Amy Coney Barrett of the US Supreme Court made these comments, it was decried upon by not only by children who were adopted, by also mothers who were not able to get abortions and had to give these children up for adoption, about the trauma that this whole process caused, and about how these choices are not frivolous choices that are made by women, but are reasonable choices that are made after a lot of thought. With that in mind, I think it might be important for us to understand what exactly Roe, what are the rights that Roe gave, and also the history behind it. So both Roe v. Wade and Planned Parenthood Planned Parenthood versus Casey were the two judgments that were overturned by the judgment in Dobbs versus Jackson Women's Health, which really helped define the contours of the liberty doctrine by first consolidating and also bolstering earlier cases that the Supreme Court had given on personal liberty. And it also later supported cases in which the Supreme Court has recognized additional liberty rights as contiguous as ones that came before. What led to Roe are cases such as Griswold versus Connecticut, Nisentat versus Baird, which gave the right of contraception to married and unmarried couples, realizing that there is a right to personal autonomy and personal sexual relationships. So when Roe came to be, what Roe did was, the essential holding was Roe is that the woman has the absolute right over her reproductive body, and that until there is, it has a 3-trimester framework, which is that in the first trimester, the state can have no restrictions at all. In the second trimester, the state may have some restrictions based on the health of the mother and the child. And the third trimester, restrictions can only be placed if there's the health of the mother as a concern. And so what Roe does is saying that the mother until that time has complete control and state cannot place any restrictions. And Roe basically framed abortion as a right broadly related to privacy. And it cites all of these cases that I mentioned before, which protect a range of rights from marriage to child rearing to education. And it finds this right in the 14th Amendment, the due process clause of the 14th Amendment, which discusses liberty. And once Roe had granted this right in 1973, there were multiple other restrictions that were placed by states. And it went up to 1992, when in Planned Parenthood versus Casey, the constitutionality of Roe was again, and whether Roe was a correct decision, that was again doubted in Planned Parenthood versus Casey. So judges in Planned Parenthood again reaffirm this essential holding of Roe, which is to say that the right to make these reproductive choices lie with the woman. Where it makes a difference is, while Roe had said that there should be a heightened amount of scrutiny, Planned Parenthood reduces this to an undue burden standard, which is to say that when you decide on the constitutionality of these restrictions that are placed, each court must decide whether there's an undue burden that is caused to either the woman who wants to access this right, or whether to the provider that wants to provide access to the abortion right. And what Casey also does is it takes away the trimester framework and introduces a viability standard, which is to say that it's only after viability, which is after the uterus can exist outside of the fetus can exist outside of the mother's uterus. That is the line of viability. That's usually at 23 to 24 weeks. Until that point, during the time of pre-viability, the state cannot place any restrictions at all. And after viability kicks in, that is when the state can start to have any restrictions at all. And that Casey also asserts that this right exists in the due process clause of the 14th Amendment. And the only difference being, as I mentioned earlier, that it was changed from a process of strict scrutiny to one of undue burden. And to give a general idea of what these restrictions are that states usually pass in the US, it might be ones that seem very innocuous to us. Things like you must have a mandatory 72-hour waiting period, or that the woman must necessarily have an ultrasound done before an abortion. While these seem very innocuous, these are reasons that lead to women not being able to access women and other persons capable of pregnancy not being able to access abortion. For instance, the main reason that that anti-abortion activists say that an ultrasound must be done is so that women are made to listen to the fetal heartbeat and cardiograph activity, so that they feel some emotion and decide not to go ahead with the abortion irrespective of their choice. Or the mandatory period. While it might seem really innocuous, think of women who might not be able to take 3 days off of work to be able to go back to a place after the waiting period to get the abortion. Think of people capable of pregnancy who might be a part of a family life with domestic violence, where they'll have to hide the pregnancy from a partner who's violent. So things like this, which might not seem like difficult barriers to overcome, are real barriers that affect people and stop them from having an abortion. So even after the right to an abortion as constitutionally protected under the 14th Amendment was set out by Roe and both Casey, states over the years introduced multiple restrictions like this. And finally, where it takes us to is even after judgments in such as June Medical Service and Whole Women's Health, where the Supreme Court upholds Casey, Roe, to say that the essential holding of Roe still holds, that their pre-viability restrictions cannot be placed by the state. We come to the summer of 2020, where a Mississippi law that bans abortions after 15 weeks is challenged before the Supreme Court, after both District Court and the High Court have said that, according to the framework in Roe and Casey, a 15-week ban cannot hold because it's a pre-viability restriction. So in the summer of 2020, when certiorari is granted, it's on a very limited question of should pre-viability restrictions be allowed or not. And very interestingly, it's a tiny footnote in their certiorari where it says that that within the Roe and Casey framework itself, a 15-week ban should be allowed. But in case it's not to be allowed, the judgments in Roe and Casey and other precedents may be questioned. Very interestingly, after the filing of the certiorari, what happens is, as you all know, Trump pretty much packs the Supreme Court with judges who are openly anti-Roe. And he makes a proclamation that he will get judges in place who will finally win this fight for anti-abortion activists and make sure that Roe is gone, which is egregiously wrong. So once this happens, this tiny footnote in the certiorari then becomes the entire merits brief of the petitioners. So the entire merits brief is only on how Roe and Casey are wrong, and the only way to go forward is to take away the viability framework that is in Casey, and that the right to decide on what restrictions should be made is to be returned to the states. And if you look at even the response to the petitioner's brief, it's really not on the merits of whether, on the merits of, whether this right finds itself in the 14th Amendment. It's really just about Roe at this point is a super precedent that has been followed for more than half a century. And Casey is precedent on precedent, which has reaffirmed it. And there are multiple other intersectional liberty cases that have relied on both Roe and Casey. And the value of it is too much that stare decisis demands that you do not touch that. And the Mississippi law must fail as it does not fulfill the framework of both Roe and Casey. And even during the hearings, it became quite clear that the 5 judges who were appointed by Trump had pretty much had their role set on the fact that Roe and Casey were both wrongly decided. So during the hearings, if notice, the respondents were really at that point just appealing to the conscience of Chief Justice Roberts to say that you must listen to stare decisis. It's against the integrity of the Supreme Court to go back on such a super precedent. Who also at that point, by this point, there had also been a challenge made to the SB 8 heartbeat bill made by Texas, which banned abortions from 6 weeks. 6 weeks is really when women even find out that they're pregnant. And once there is a ban on abortions, it's particularly effectively just banning abortions across the state of Texas. And the Supreme Court at this point, these same exact 5 judges had said that they will not ban the operation of this of the SB 8 bill. And even at that point, Justice Roberts had dissented in that to say that this fails Roe and Roe must be upheld. But the viability framework, it was not clear where he stood on it. So throughout the hearings as well, they were really just appealing to his conscience because the lawyers pretty much knew that there was no winning over the other side. But the majority opinion, as we all know, held that pre-viability restrictions are all right, as long as the states are deciding it, and said that both Roe and Casey are wrong on the fact that there is no effective right of liberty and the right to abortion that is granted under the Due Process Clause of the 14th Amendment of the US Constitution, and that Roe was egregiously wrong to read this right in. And Justice Alito, who wrote the majority opinion, also says that unwritten rights must be rooted in history and practice, and because of this, Roe's finding is egregiously wrong. It's actually only natural that this right wouldn't have been written into the US Constitution or thereafter the 14th Amendment, because as the dissent correctly notes, people didn't ratify the 14th Amendment, men did. So it's natural that the right to abortion wouldn't find itself. And not just the right to abortion, but even other progressive rights, which have now found its way as interpreted into the 14th Amendment, did not exist at the time. For instance, like this idea that these rights must expressly find themselves and rooted in history was said in the case of Obergefell versus Hodges, where they said that just because it's not found rooted in history does not mean that it cannot be interpreted by a progressive court. And it also said that to read the Constitution to protect contemporary norms and practices that evolve while rejecting the idea that rights can only be defined by looking backwards to a time when they were less inclusive. So Supreme Court is also then, in the case of Dobbs, violated the doctrine of non-retrogression, which is that once when an unenumerated right is given, you can't take it away. So in the judgment in Dobbs also says that this is not the first time that we've taken a right away, where we've changed a long-standing precedent. We've also done that in cases of Brown versus Board of Education or Plessy, where long-standing cases of segregation were overturned. But this is just wrong, because it's the first time that a right that was granted was taken away, thereby violating non-retrogression. And immediately after this has happened, of course, as I mentioned earlier, a lot of trigger bans went into place, effectively ending many abortion providers that existed in multiple states. Most worrying, of course, as suggested by a lot of people before the judgment in Dobbs even came, was that this attack would not end with attacking the right to abortion itself. That will impact a lot of other cases that involve the liberty. For instance, like if you see Justice Thomas's opinion, you will see that he says that the cases of Griswold versus Connecticut, Lawrence v. Texas, and Obergefell versus Hodges, which are the cases that declare that married couples have a right to contraception, the ones that invalidate sodomy laws, and the ones that establish the right of gay persons to marry, that all of this, while following Roe and the interpretation of liberty into the Due Process Clause of the 14th Amendment, must all be revisited. While Justice Alito, in his majority opinion, says that this interpretation of liberty in the 14th Amendment will only affect case of abortion. The same Supreme Court has a history of saying this in other cases and then not keeping up that promise. For instance, earlier when Justice Scalia was part of a judgment that really expanded the right to carry arms under the Second Amendment, he had also said that it's not going to affect rights in other spaces. But just a week before Roe was passed, the same idea was used to expand the idea of the Second Amendment. So this is a moment where people in the US are genuinely terrified of all these other acts, all these other rights that have been given to them being overturned. Because as once Roe and Casey have been overturned, every case that is adopted like a capacious view of liberty to assert that the Constitution protects private choices and bodily integrity are now at risk. Since understanding this, just today, the House of Representatives in the US have voted to make it a federal right to have contraception, because there are multiple states who, since the overturning of Roe and Wade, have tried to bring in bans on contraception. And it has passed in the House of Representatives, but once it goes to the Senate, you really have no idea, which is both Democrat and Republican controlled, as to what will happen to it. So there's certainly work being done in the US to not only challenge specific state laws, which are being done by multiple lawyers on charging specific bans that are coming in, but also to bring in federal protection. But considering the political situation, you really don't know what happens. Taking this into account, but knowing all of this and as upsetting and how detrimental it has been to multiple people capable of pregnancy in the US since the fall of Roe, Roe has not been without critique. Even since the passing of Roe and after, even though Roe has been a right, Roe gives you a right to abortion, that has not meant that it has had an effective implementation. It's really important for us to think of, even though there's a right granted, who is able to access it? Because what good is a right without the ability of all people to access it? So it was really understood that, and a recognition that the women's right movement and how the reproductive right being made synonymous to the right of abortion was really led by white feminists and white women feminists, who really did not take into account the impact and other intersectional approaches that are necessary to be taken into account while looking at who gets the right to abortion. So in 1994, the term of reproductive justice was coined, which looks at reproductive health and rights through a more inclusive human rights and social justice framework, which not only looks at narrowly at the right of reproductive right as a right to abortion, it looks at your right to have a child, to not have a child, the right to bodily autonomy, and most importantly, which a lot of people just seem to forget, it's the right to parent your children we have in safe and healthy conditions, regardless of age, sex, gender, and sexual orientation. So this is not something that is discussed even in all of our moral or legal debates about whether abortion should be allowed or not be allowed. It's really important that when people, when they're capable of pregnancy, when they make these choices of whether they want to have a child or not, it's really based on their reasonable and foreseeable conditions of how they can bring up the child. And that is a main aspect of reproductive justice as well. So when we're thinking about this reproductive justice versus reproductive rights movement, we have to think of it in a more holistic and more expanded way so that we can understand really of oppressive systems that create barriers to accessing this right, whichever country it may be, on these systems that create these barriers that make sure that even though there is a right, you're not really able to access it. So when we conceptualize our pursuit of reproductive freedom, we really have to acknowledge the ways that our systems and structures fail minorities, fail indigenous communities, and also acknowledge caste and class divides that impact these barriers. And a main lesson from the fall of Roe was that people had their hopes wrapped onto just one judgment. There's no legislative protection. It was just this one judgment that was saving people for 50 years, irrespective of how many ever people it was able to save and how many minorities it might have failed. And it's in one fell sweep, it's just gone. One day you wake up and it's just not there, and you just have no protection, which really makes you understand that it's not just this one right that is granted by courts or a legislation, but these building blocks that you create around it that make sure that it's not so easy for the state or anybody else to take these rights away. Like an example that comes to mind is, I remember when the Aadhaar challenges were happening, we all grew up learning that privacy was part of Article 21. That was never something that was in question. And one day we woke up to newspapers saying that the center thought that privacy was not a part of Article 21 anymore. And it was just shocking to all of us. Thankfully, the Supreme Court reasserted that right and said that it is indeed a part of Article 21. But it really made us understand how quickly those very essential rights could just be taken away. But even saying that, while Puttaswamy has said that privacy is actually a part of 21, we need to think about how is that right being effectuated. And with that, we should talk about how the right to abortion that people say is so easily available in India, and how is the access actually granted. I remember the day after Roe was overturned, there was a barrage of people Indians on social media saying that we finally beaten the West. We are so much more progressive than the West, without really understanding what the status of our laws is, or who's able to access it and how people are able to access it. It really only shows the ignorance of the caste and class divide that most of us have to think that this is an absolute right. This is a study conducted by the Center of Reproductive Rights, which shows that there are about 8 lakhs unsafe abortions a year in India, which accounts for about 10% of maternal deaths. and about 27% are unsafe abortions that are conducted at home. It really tells you about how the state of reproductive rights in India and abortion rights in India. And it's also really impacted by, like, different from the US. We also have a lot of cultural baggage that comes in, which complicates this further. Most women who are probably attending this talk can testify to the fact of how difficult appointments to medical practitioners or gynecologists are. How all of your right to have threatening medical care is really decided on that one question a gynecologist asks you when you enter: are you married or not? And on that basis of that one question, gynecologists really decide whether to give you care, whether you deserve care. I'm sure a lot of us have come across crowdsource Excel sheets of gynecologists who are sympathetic and empathetic and who are actually sensitive with how they deal with women. It's not just women, all people capable of pregnancy. So the way that the doctors also operate and other members of this whole, the gamut of the bureaucratic maze that is the MTP Act really causes a real problem to access. And this stigma, as I mentioned, in the Indian society that exists, along with the lack of mobility and financial agency, still restricts heavily the access to abortion of people capable of pregnancy. It's very important for us to understand, while we talk about that abortion rights are easily granted in India, about how the MTP Act came to be. The MTP Act is not centering the autonomy of the woman. What it really does is creating a maze of bureaucratic hurdles that a woman must go through, a person capable of pregnancy must go through, to assert a very basic right of reproductive autonomy. It's only given as an exception to a crime under Section 312 of causing a miscarriage under the Indian Penal Code, so as to save doctors. It's not something that centers women or their choices or their health. It's a completely legal framing, which takes away the choice from the woman and rests it entirely on the doctor's opinion, or now on the opinion of a medical board, or in the opinion of a judge who thinks whether that person is someone who deserves an abortion. It's also important to mention that the MTP Act, in contradiction with other laws and judgments of the Supreme Court, only very restricted, in a narrow way, only speak about women and does not talk about non-binary persons or trans men, who also then daily struggle to take control of their birthing choices and their bodily autonomy. It's also really interesting that in India, there are rampantly sex-selective abortions that happen. But at the same time, there are people who are ostracized and faced obstacles to exercise their choice of reproductive autonomy. This again makes India like a cultural and all these complications that come in with India while we talk about abortion rights. There are also, with the stigma that is created, there are also issues with emergency contraception, pills or other drugs that is allowed under the law for women to access, which are not available. There was recently a study conducted by the News Minute on the lack of availability of emergency contraceptive pills in Tamil Nadu, while also remarking about the lack of these pills across India, and also about pills that are allowed under the MTP Act of mifepristone and mifepristol not being allowed due to problems of how the regulation of these drugs happen, because of although they are allowed under schedule of the Drugs and Cosmetics Act. And we also have to really think about how the earlier barriers that I spoke about that might seem innocuous to all of us. Going to another state, if any of us are not able to get an abortion, it's not very difficult for us to travel. It's not difficult for us to take a day off work. It's not the same for everyone. It's not the same for people who've undergone domestic violence. It's not the same for someone who cannot tell their husband or their partner that they want to get an abortion, or their parents that they want to get an abortion. There's also issues of main issue of like minors being affected because of the mandatory reporting clauses in POCSO. The mandatory reporting essentially means that you will have to tell the doctor that there has been abuse if you want to get an abortion, and the doctor essentially has to report it. Research has shown that most of the offenders under POCSO crimes, about more than 80%, are close family members. This not only leads to underreporting, but also stops these minor children and their families from wanting to go to a doctor to get an abortion, which again leads to more unsafe abortions. This really also just shows how there is, like most of our laws, there is no effective consultation with stakeholders while these laws are being created. By stakeholders, I mean people who have lived experiences through these issues, as well as people who are working on the ground with these people to empower them. If there was effective consultation, then this probably would not have been the situation. Another issue is, of course, as I mentioned earlier, the bureaucratic hurdles that are created by the MTP Act, and also that the regulation is done entirely by the doctors themselves and not by the choice of the woman. This is not just a problem with unmarried women and stigma. Even married women face this problem, where if they have made a choice based on their family situations, economic and social circumstances, they do not want to have a child. And if they go to a gynecologist who has to grant them the permission to get an abortion, that they're often emotionally guilted into carrying on with the pregnancy and not an abortion. Another problem that, which I think is actually requires much further discussion, but I'll just leave this strand of thought here for maybe someone to, maybe you can have a discussion about it later, is just how most of our abortion laws, not just in India, but abortion laws across the world, have a basis in eugenics. And this is by most of the exceptions that are granted for severe fetal abnormality or other disabilities. And what it really does is you're telling disabled people that their lives are not good enough, that the quality of life that they will have will never be good enough for the society to accept them. Of course, realities of society, financial problems will make a woman want to choose not to abort a child who might have a disability. But instead of creating access for them to be accepted in society, for them to have accessibility in society, what we're eventually saying is that we are preventing the births of disabled children. And this is something that was there. So even if you look at the debates of the MTP Act before it came into force, there was a specific member who said that we should add a clause of sterilization into the MTP Act to make sure that parents who cannot have healthy children must be sterilized. Thankfully, it didn't make its way into the MTP Act, but it really tells you about how people view it. Even in the US, Margaret Sanger, who was a founder of Planned Parenthood and one of the major proponents of abortion care and right to contraception, she was recently disavowed by Planned Parenthood's office itself for her views on eugenics. That the idea that abortion was being pushed so that they could control the number of Black babies being born. So it'd be really interesting for us to really think about, when we're talking about severe fetal abnormality, to think about how there's a eugenics based, and to discuss how the hierarchy of disability rights must be thought of as well. And the US, it's also, this contradiction is actually really interesting, where reproductive justice activists have been pointing out constantly, where there seems to be an uneasy alliance between disability rights activists who would usually find on the pro-choice side, on the pro-life side, because you see pro-lifers co-opting the language of disability rights activists to say that the lives of disabled children are so important and hence abortion should not be allowed. So the co-optation of language by the other side, while using the voice of disabled people, is also an extremely interesting thing that happens there. And to now talk about how there is kind of a judicial arbitrariness that really exists with how abortion rights are looked at in India. In the past, before the MTP Amendment Act of 2021, the Supreme Court has mostly granted permission, Supreme Court and different high courts have mostly granted permission to undergo abortions to minors, women carrying fetuses with substantial abnormalities, and to survivors of sexual assault. They don't really have none of these have necessarily a constitutional question attached to it. Instead, they're really just responding to emergent situations to save the lives of the women or the child. What this has led to is a very arbitrary interpretation of what the act is, of who is allowed to get an abortion, who is able to access safe abortion. While after a barrage of cases where different high courts and Supreme Courts were approached constantly after 20 weeks to get abortion, the response to that was the amendment in the 2021 Act, where medical boards were necessarily set up. What this does more is to create only more hurdles. With something like this, like a pregnancy that is so time sensitive, you're only adding more medical boards, hence adding additional barriers. We also have to take into account the lack of availability of doctors in our country. And the new rules also add on number of qualifications that doctors are required to have to be able to give abortion care. So you're really only through the amendments as well, adding additional barriers to access. And as I mentioned earlier, just also very different interpretation by multiple courts. You see, because of these bureaucratic hurdles, a case in the Orissa High Court last year, where there was a minor who was a survivor of rape, and she was sent to multiple doctors for medical reports. And she had reached such a stage due to the delay caused because of wrong reports given by multiple boards, that the court said, we are really sorry. We wish we could grant you, and you deserve to get an abortion because that is your wish and it will impact your mental health. But we cannot because of the delay that was caused by the medical boards. We also see cases like that was heard by the Delhi High Court last week, interpreting the new MTP rules of 2021 to say that it doesn't cover unmarried women. I would just like to clarify that it's under the rules and the exceptions. It's not just unmarried women. What it basically looks at is a change in marital status. So if from the starting of the pregnancy to afterwards, you've had a change in your marital status, that is if you're a divorcee or if you're a widow, then you are under the exceptions which will grant you a termination from the week of 20 to 24. So it's not just unmarried women. So if you were to look at the rules as strictly as the Delhi High Court did last week, then even a woman who wants to get a divorce, who's in the process of getting a divorce, would also be covered under this and would not be able to apply for a termination after 20 weeks. You also have to see that it's the same Delhi High Court in a case last year who expanded this right and said that reproductive autonomy and reproductive right and the right to abortion is so integral to Article 21. And you see the same High Court acting this way to pass the remarks that it did and to say that it will not allow termination. And so it shows you it's really just all about subjective decisions that are made by judges in these cases and not a consistent application of the law or application of the discretion under Article 226 or 32. Just the day before this judgment of the Delhi High Court, there was actually a very good judgment of the Kerala High Court, which allowed a woman, a minor child who was past 24 weeks to have an abortion. And the judge remarks that in cases like this, the choice of the woman and the safety of the woman should be paramount and not rigid interpretations of the law. You should also see it against very progressive judgments of the Bombay High Court, where they're looking at the mental health of the woman and the reasonable and foreseeable risk that she herself is able to choose as being the ground on which choices of abortion are made. This is also not the first time that we've had cases like this, where women's choices to have abortion have been questioned in courts. There was a case in 2018 in the Supreme Court, where the judge specifically asked the lawyer who was representing the woman that who you should be representing is not the woman, but the unborn child. And you should ask your client to listen to the heartbeat of the child. And then maybe she might not want to have an abortion. I personally think that this is a form of paternalistic condescension that is shown as care for the unborn fetus. And I think also instances like this with judges and other healthcare providers like doctors attributing a personhood to a fetus, like during the hearing, calling a fetus an unborn child, calling the woman a mother. All of these it creates an opportunity for people to decide based on their personal beliefs and not as a way to implement the law and to uphold the absolute right of sexual autonomy of a person capable of being pregnant. All of this is not to say that certain judges are wrong or that the law is wrong. It's only to say that because of the vacuum in the law about not being an absolute right, because it's still being criminalized, because of the inconsistency of application, a person who's pregnant does not know where they stand if they find themselves in an unwanted pregnancy. And it all then is tugged on to a subjective belief of that particular doctor or a judge that in front of. And also comments like this that are passed by judges. Very interestingly, in a Bombay High Court suo motu case, this point of choices that are made by women was especially judicially recognized. I'd just like to read it out. The judgment said that a woman's decision to terminate a pregnancy is not a frivolous one. Abortion is often the only way out of a very difficult situation for a woman. An abortion is a carefully constructed decision taken by a woman who fears that the welfare of a child she already has and of other members of the household she's obliged to care for with limited financial and other resources may be compromised by the birth of the child. These are decisions taken by responsible women who have very few other options. If a woman does not want to continue with the pregnancy, then forcing her to do so represents a violation of the woman's bodily integrity and aggravates her mental trauma, which would be detrimental to her mental health. The Bombay High Court has also looked at this more expansively on what mental health of the woman is supposed to mean, to say that it's not just a narrow view of what you or I would think of mental health, but a choice the woman makes after having a reasonable opinion of her situations herself, because the right at the end of it must end with her. It's also a social reality, right? Which the Bombay High Court also talks about. That while we might think that in a marriage or even outside of a traditional relationship where there might be a man and a woman involved, the social responsibility usually always ends up on the woman of child rearing and taking care. So really it's on her to decide and weigh her options on whether she's able to give that child a good life, on whether her mental health is at risk, or if her other family members are at risk. All of this I would really just like to conclude on saying that we've seen how quickly this half a century of rights in Roe v. Wade and Planned Parenthood versus Casey, how quickly it fell and how it has led to extremely drastic consequences for people in the US. We might really think that that's not affecting us, but really reproductive injustice anywhere is a threat to people everywhere. You will see people using those the examples from Roe now in pushing anti-abortion activism all across the world, including in India, perhaps. So we really need to understand the issues and why they were able to deconstruct Roe so quickly, and not just because of packing of judges, but also to understand that if there were issues of barriers to access that had been removed, maybe just taking away of this right that is mentioned in a judgment would not have affected people so quickly. So when we're thinking of this in the context of India, we should really try to have a more expansive, holistic approach to not just looking at reproductive rights, something that is so limited, but to view abortion as a healthcare option, and to also look at other reproductive health options that must be made available to women. And also, as I mentioned earlier, also think about how disabled people are treated. And you're thinking of, you must create psychosocial support for parents who might have disabled children, instead of saying they do not have a life worth living. And if anyone is more interested to read more about this and work being done, I would suggest that you look at, for the US websites, the Center for Reproductive Rights that has extensive work on this and life tracking, as I mentioned earlier. Or in India, there are very excellent reports looking at analyzing abortion laws and reproductive healthcare access laws in India. Studies done by the Center for Constitutional Law, Policy and Governance in New Delhi, done with the Center for Reproductive Rights, or for a very good statistical analysis of judicial arbitrariness that exists with interpreting the law. There is a study done by the Pratikya campaign. Yeah, thank you.
That was an extremely interesting session. You've given us a lot of food for thought. Thank you very much, Advocate Nini, for sharing your academic insight on this issue. So we have a few questions for you. Shall I read them out?
Yeah, sure.
Why do you think that this concept of abortion rights was left to state decisions and not statutorily guaranteed in the America?
That's a political effect, really. They've never really had the power to be able to statutorily grant these rights by law. There are some states that have had these protections. There are states like New York, which now have statutorily granted the right to abortion. But in most of the states where the Democrats don't really have much of a power, that's why that hasn't been granted yet.
Okay, moving on. Do you think that the proposition put forth by Mary Ford that fetus is best understood as the property of the pregnant woman is correct?
I don't think if a person's intention is to ensure that a woman has absolute reproductive autonomy over her body, I don't see why that is the line of thinking that one must take forth. There is, as I mentioned earlier, there are a lot of other options of a holistic rights-based framework that one must create. I don't see this as being a creative argument for how we can do this. I also think that issues like rights of an unborn child, rights of a fetus are all really muddying the water. While what we should be fighting for and what law should do is things like decriminalizing abortion, is to create these access that I spoke about earlier. I mean, there's also possible that the moment you introduce property rights, there's also things that can happen where the state says it can expropriate property for public purpose. So you really don't want to be introducing things like that into this very personal choice, I think.
Another question that's come in is, so despite having commendable laws, the ground reality is that our Indian women still don't exercise complete autonomy when it comes to their reproductive choices. In your opinion, what more is required?
As I mentioned earlier, the first thing that one of the main things that should happen is abortion should be decriminalized for this stigma to be over. There's also a complete lack of awareness that people don't know about what the MTP Act grants them. There's also a main problem with a lack of sensitive, empathetic doctors on the ground. So there's really a need for discussions with stakeholders before laws are decided. And there's also more importance to be able to empower the groups that are working on the ground with women, so that people are made more aware of rights that are available for them, and so they can advocate for better change. And also problems of caste and class divide are things that many of us are not aware of. Innocuous access barriers that we are not issues to you and me are problems to a lot of other people, which we are not aware of. I think we must also constantly educate ourselves to understand and then help and empower other people.
Okay, thank you. Could you briefly share your experience as a Fulbright scholar and how you navigated the application process? What advice would you offer to someone who is contemplating undertaking an LLM?
I think I'm very grateful for the Fulbright experience mainly because it's really the only scholarship out of all of the ones that are available where a decision is told you by September. So 2 months before you even start applying to universities, you really have that burden of a financial burden that is taken off of you, and you can calmly just focus on making applications. I think the most difficult part of making applications for an LLM is just finding clarity over what you want to do, like a narrow research question that you want to study. Once you have that clarity and once you're able to create a storyline of convincing the colleges and scholarship applications that is why you want to study this particular very narrow research objective, I think the work is done. You will need to create this storyline with your work experiences or your educational background. So it's very important that you take some time and think about what that research objective still is. I think I had a very productive LLM experience, especially after having studied in India for law school. My friends and other people also who went to law schools in India, we've experienced where even very good professors who would come in and ask us to do readings before class, we'd see students protesting about how dare the professor give us readings before class. So with all of that, I didn't think that I would have a year of absolute academic enrichment. I wasn't really expecting that when I went. But just the fact of how systems such as ensuring that you're doing all of your readings before class, you're reading like 200-250 pages every week before you go for class, and you have professors that engage with you extremely critically on those readings, where you're able to have constant discussions, where you're able to have experiential learnings that are happening. All of that was very interesting to me and was very helpful in just being to take that year away to spend just on an area of interest and to be able to think more about it.
Okay, thank you. Another question that we have is, do you think that the exclusion of choice as a reason for abortion is something that needs to be corrected in the Indian context?
Yeah, absolutely. I think that's a main problem of the MTP Act and even other judgments that have dealt with it. The MTP Act does not center the choice of the woman at all. All it does is save medical professionals from prosecution under the IPC. So we need to really change our outlook of how we look at the right to abortion and generally reproductive health care, where abortion only becomes a part of reproductive health care and not something that people capable of pregnancy are constantly demonized for. And the MTP Act needs to center the choice of the woman or the person capable of carrying pregnancy to decide what they want to do. And the whole way that, as much as we can cry hoarse about how MTP Act is a very progressive act, and even other acts like the Transgender Rights Act are very progressive, these are all done without stakeholder participation, which shows up in why there are so many protests by people who are actually affected by it. So the outlook itself on how we look at these acts, even when we might claim they're progressive, needs to change. And the main thing that has to be done with the MTP Act and abortion laws in India is to make sure that the choice of the woman or the choice of the person carrying the pregnancy is penultimate.
Thank you very much, Nini. Before we end today's session, I must mention the people who made this event possible. First and foremost, our esteemed speaker, Advocate Nini Susan Thomas. Thank you so much for taking the time out for this lecture and to share your valuable thoughts on this contemporary issue. Also, we are grateful for the information you shared regarding higher studies abroad. You truly are an inspiration for all of us young lawyers. I must thank Honorable Mr. Justice S. Manikumar, Chief Justice of the High Court of Kerala and President of the Indian Law Institute, Kerala, for his unwavering support in all our activities. I also thank Honorable Mr. Justice Alexander Thomas, Executive Chairperson of the Indian Law Institute, Kerala, who is truly dedicated to ensuring the success of ILI's online lecture series. I also thank Advocate Sanjay, Advocate Shyam Kumar, and Advocate PJ Jayashankar for their meticulous planning and organization that culminated in today's lecture. I must also mention my gratitude to the staff of the High Court who ensured that the event was streamed without any technical hitches. Lastly, I thank each one of you who has joined us virtually to make this lecture a fruitful experience. Thank you all. With that, we come to the end of today's event. I wish everyone a great evening ahead.